Every night on a dark Kansas highway, a deputy sat in his car with the headlights off, waiting. When a car passed, he flipped on his high beams, looked at the windows for a fraction of a second, and decided whether the tint broke the law. No measurement, no device. Just his eyes, a passing car, and a guess. And that guess was enough to pull people over, night after night. His name is Deputy Blake Fisher, and the law says an officer needs a real reason to stop you, not a hunch. So when he pulled over Miss Cowan for tint he claimed was too dark, her attorney asked the one question that mattered. How could you possibly know, in the dark, as a car flies past you at 65 miles an hour? The deputy had an answer for everything. Training, experience, he does this all the time. But there was one thing he forgot. His own dashcam was recording that night, and when the defense played it back in court, it told a very different story than the one he just swore to. For over 30 years, I sat on the bench. An officer can use his training and experience, but experience is not a license to guess. Watch a judge draw that line, and watch a deputy's own camera cross it for him.
And were you able to see into Miss Cowan's vehicle?
No.
Now, I know we had gone over this before, so when she went in front of you, what, if anything, can you describe to us, did the interior look like?
I can't tell you what the interior looked like. It was too dark.
And if someone has correct window tint, are you able to see how many people are in the vehicle?
Yes.
And have you been using this technique for a while?
Yes.
He says he has been doing this for a while. Let us take a quick look at what that actually looks like on the road.
Oh, good. How are you?
Well, I'm good. Oh, man, that's disrespectful, man. What is that for?
What?
She's got a migraine headache bad, dude.
Okay.
Like, seriously.
Okay. Do you have your driver's license, insurance,
No,
registration?
she's the one that's got the driver's license, and she's got a migraine headache. Would you please not shine that in my light?
I'm going to do what I can do,
But
okay?
that's not.
I don't care. Need your driver's license,
I
insurance,
don't have a
registration.
driver's license and insurance.
Okay.
She does.
Yes.
Can you roll down your window a little bit? Right there. Put it about halfway for me. I'm going to test the window tint on it, okay?
Yes, sir.
You know what the legal window tint limit is in Kansas?
Well, like, this car's been like this ever since I've had it.
Don't matter. Do you know how what the window tint is?
Like, yeah.
That's at 30%. Okay, so you're 5% below the legal limit.
Okay.
All right.
No,
Huh?
that's not good.
That's bad.
And have you become more experienced at using it on a daily basis?
Yes.
And when you stopped this car, did you eventually test the window tint?
Yes.
What was the window tint reading of the vehicle when you were able to test it?
I'd have to refer to my report. I don't have it in front of me. I'd have to pull it up real quick if that's okay with the court. It was 11% window tint.
What is the legal percent in the state of Kansas?
35%.
And now, Deputy, when you fill out your probable cause affidavit, because I know this question was asked at the prior hearing on the same exact motion to suppress, is the probable cause affidavit designed to be an end-all be-all of everything you do on a traffic stop?
No.
What is it only for your probable cause bare minimum?
Just for the arrest.
All right. Do you explain every time you go through a case, all of your experience or how you use specific testing?
No.
And so is there anywhere in your report you explain how you use your experience and this technique of checking windows?
Not that I believe.
I will pass this witness to the defense.
Cross-examination, Mr. De Hoyos.
Judge, thank you, sir. Deputy Fisher, I want to make sure I understand the way in which you determined the windows were too dark. How long did you have to observe the vehicle that you pull over?
I don't know an approximate time frame. I mean, she was driving by at highway speeds.
Okay, and that highway, that's US 54 or 54 400, is that what that is?
400,
Forgive me, 400. Is 70 there? 75?
65.
65. Okay. Um, Middle of the night, right?
Correct.
And you say that the technique you employed was you had you flash your high beams to see if you could see through the windows, is that right?
I don't flash them, I sit with them on.
Okay. So you sit with them on and help me understand what happens after that.
As the vehicle drives by, I make my observations.
Okay. And is there, I mean, is this a lawfully approved technique? I mean, is there a sheriff's or a county association or any kind of police association that approves of this technique?
Mm, Not that I know of. I mean, it's reasonable suspicion. She drove by, saw that the window tint appeared to be too dark, so I had reasonable suspicion to believe that the window tint was too dark, so I initiated the traffic stop.
So hear me out, Deputy Fisher. I appreciate that. When it comes to the lawful definition of reasonable suspicion, all that, I'm not worried about that. I'm trying to understand the facts. And the fact is, you use a technique that has not been supported by any lawful community that or law community that you're aware of.
No, we all use it.
There is the first crack. The defense attorney asked a simple thing. Is this method approved by anyone? Any sheriff's association? Any police department? Anyone at all? And the deputy's answer is no, not that he knows of. The only defense he offers is, we all use it. Here is why that matters. To pull you over, an officer needs what the law calls reasonable suspicion. Specific facts pointing to a real violation, not a feeling. A method that no training body approves, that has no manual, no standard, no science behind it. That is not a specific fact. That is a habit. And everybody does it has never been the same thing as it is reliable.
Okay. Have you ever seen a study on the error rates of something like that between the difference of being able to identify too dark and not too dark?
No.
Do you think that difference would allow you to understand negligible difference, like the difference between 33% and 37% dark?
If I took a class, it might.
But as you stand there, your experience is not allowed to decipher differences like that in a passing glance.
You said what?
As it stands right now, you don't have the experience to be able to say that in a passing glance what percent the window tint is.
I can't tell an exact percentage, no. And I don't think anybody would be able to tell an exact percentage, but I know that if a vehicle is driving by and I can't see into the vehicle, it's reasonable to believe that it is too dark.
Okay, so if somebody drove past you while they're holding a blanket against the window, does that mean their window tint is too dark?
No.
Okay, but that would still create the same effect that you not being able to see through the windows and then pulling them over because the window tint is too dark, even though that wouldn't be true, right?
I would disagree with that.
Okay, which part?
Well, if the window tint was not too dark and they drove by and they were holding a blanket up, I would be able to see that they were holding something up. As she drove by, I wasn't able to see her or any other person in the vehicle, indicating that the window tint itself was too dark.
Okay. And are there any outside circumstances that can affect your judgment as to the lightness or darkness of the window tints as they fly by at 65 miles an hour?
As in,
Oh, I don't, in a storm, would you just make the same call? Would you make the same pullover and same arrest?
I mean, it could alter some, I guess, but no, not really.
What if it's an all black background that they go against?
If it's an all black background, there was no other lighting where we were, so it was an all black. We were sitting stationary in the middle of the county, and the only high beam headlight or the only lighting that was shining on the car was my high beam headlights.
Yeah. No, I guess what I'm asking is if on the other side of that car was all black, that you don't think that would affect the way you reviewed that car? It wouldn't make things look darker than they were?
I'm not understanding your question. I don't see what an all black backing would be on the other side of a vehicle.
I'm just trying to see if that makes a difference. If the background was all black versus nothing else back there, would that make a difference about the transparency of those windows?
I'm gonna say no.
Okay. So at the time in which you observed the defendant's vehicle, Was it by itself or was there any other vehicle within its proximity?
It was by itself.
Okay. So if the video of you observing that, I think it was a Chevy Sonic, demonstrates that it was right next to and alongside an 18-wheeler that was all black and that you observed it with the all black background, that would not be consistent with your memory and the way you would do this technique. Is that correct?
I mean, from what I can recall, like I said, I haven't been through the video, I haven't been through the report. From what I can recall, what I saw was her. I wasn't paying attention to any other vehicle. And it was the front passenger side window that I was paying attention to. She was closest to me. We were in a 4-lane highway. She was heading eastbound. She was the closest vehicle to me. So I was looking at that window specifically.
Okay. Well, I appreciate that. Jill, I have a body or a dash cam video. This is 234A that I want to admit, but I've never tried to admit a video on Zoom court.
Sharing's not turned on.
It should be good now.
Can you see it okay, Judge?
Judge, if I may resume cross-examination.
Yes, please resume cross-examination of the Deputy Fisher.
Just real quick here, Deputy, that's a true and accurate copy of the video that would have been observed from your dash cam that night. Is that right?
Correct.
Okay. And there was at least another vehicle on the roadway, that being the semi that was behind the defendant's vehicle. Is that right?
Yes.
Okay. And do you agree that that's a little different than the testimony that there was another vehicle with it? There was another vehicle with it, right?
Yes.
And here is the moment the case turns. On the stand, under oath, the deputy said the car was by itself, nothing around it, just him and her window. Then the defense plays the dash cam, the deputy's own camera, from his own car that night. And there it is, a black 18-wheeler, right beside her car, filling the entire background behind those windows. A dark truck behind dark glass, on a dark highway. Of course he could not see through that window. It was a wall of black steel behind it. His own camera contradicted his own testimony. He said the car was alone. The video says it was not. And once an officer's sworn word does not match his own recording, a judge has to ask what else does not hold up.
That's all I got for you, Deputy. I appreciate that.
Any redirect, Ms. Gillette?
Yes, Your Honor. Now, Deputy, he's asked you lots of questions about what was behind the vehicle, but you said you were concentrated on the front window and inside. Does it matter what's behind the vehicle?
No.
And your testimony was that you're focused on the window. Are you focused on being able to see what's in the vehicle versus behind the vehicle?
Yes.
Now, I kind of alluded to this before. I get to spend a lot more time with deputies and talk to them. I've even done ride-alongs. Based on your experience, can you tell when a vehicle is approaching, if it's faster or slower than what should be normally the speed of the vehicle?
Yes.
How can you tell?
Based on my training and experience, I've been doing this for long enough to know that the way the vehicle is oncoming towards me, I can kind of adjust the speed in my head and kind of see how fast it's going, and then I affirm that with my radar.
Now, is it the same when you're doing these window tints?
Yes.
But you need radar to tell what the exact speed is.
Correct.
So if a vehicle is approaching you from the front, do you change your radar to your front?
Yes.
If the vehicle is approaching from the back, what do you do if it's approaching from the back?
Switch my radar to the rear.
And you said all of us do this test. What do you mean by all of us?
Like deputies and officers in general, we use the same practices.
So to your knowledge, are there other deputies using the same practice of using the high beams to see into the vehicle to see window tint darkness?
I would assume so, yes.
Do you do it on a frequent basis?
I do.
Listen to that answer, because it changes what this case is really about. This was not one bad night. This is not a single mistake. The deputy just told the court he does this every single night that he works. Sit in the dark, high beams on, guess at the tint of cars flying past, and pull people over on that guess. Whatever the court decides about Ms. Cowan, understand the scale of it. Every driver on that highway every night was being judged by an eyeball test with no science and no standard behind it. When a method this shaky becomes a nightly routine, the question is no longer whether he was wrong about one car. It is how many stops were built on nothing but a hunch.
How often would you say you do this?
Every night that I work.
Judge, I'm going to object to the rest of these questions. If the strategy is inappropriate from the beginning, it doesn't matter if he does it 1,000 times a day.
Now,
Objection sustained.
I'm getting to my point, Judge, because experience, based on the experience and totality of the circumstances, is what he needs for only reasonable suspicion. He doesn't have to have probable cause. And he's already said he could reasonably infer that her window tint was too dark. And we're getting to his experience here. Deputy, are you provided with a tool to measure window tint?
I am.
Are you able to use that while a vehicle is in motion?
I am not.
So if you have a reasonable inference that the window tint is too dark, do you effectuate a traffic stop?
I do.
What happens when you effectuate a traffic stop with a reasonable inference that the window's too dark?
After explaining the reason for my stop, I test the window tint.
Can you test it at night?
Yes.
Can you test it during the day?
Yes.
If someone's window tint is legal, what do?
I let them on their way.
If the window tint is too dark, then what do?
I take further action, whether that's issuing them a warning or a citation.
Now, in this case, based on your experience, did you have a reasonable inference that this window tint was too dark?
Yes.
Once you stopped the vehicle, did you conduct the window tint test?
Objection to relevance.
It's relevant if he confirmed that it was too dark.
By that time, we're saying it's already illegal, so it doesn't matter.
Objection sustained.
Now, does any officer or anyone have a test they can do on windows prior to stopping the vehicle if they have a suspicion?
Not that I know of.
Objection to relevance.
Objection sustained.
Judge, it's relevant because if there
Objection
is no,
sustained.
is there any device that you've been provided that can test a window before you have the reasonable suspicion to stop it based on your experience?
I'm going to object to that as for a legal conclusion.
No, it's asking if he has a device.
Well, the request of before that's the
Objection
problem.
overruled.
Do you have a device that can test window tint before the stop?
No.
Do you have to stop the vehicle to test the window?
Yes.
In this case, based on the totality of the circumstances, the technique in which you were trained in your experience, did you have a reasonable suspicion her window was too dark?
I did.
Now, besides the window tint being too dark, was there anything else that drew your attention to this vehicle?
The driver herself.
Okay. Now, I'm gonna ask.
Wait a minute. The court makes inquiry. It's the court's understanding that the deputy is now testifying that the defendant herself he could see the defendant herself. Is that what's being testified to?
This
with
is
this too dark a tint at night, windshields?
Judge, my recollection of what Miss Jill Gillette was asking was after the vehicle was stopped.
Okay, court stands corrected. Thank you.
Now, but your initial stop was based on the window tint.
Correct.
Okay. And which window was rolled partially down?
I'm going to object to relevance.
It's irrelevant because if the driver's side window was rolled partially down or the passenger side window was rolled partially down, if he can't tell that the other window was rolled down until he stops, that's further evidence that he couldn't see into the vehicle because he couldn't see her and he couldn't see into the vehicle.
I'm confused. Are you saying that the window
I'm
was partially?
confused also. What about the rolling down of a window makes it relevant as to the tint percentage darkness to the windows?
I'll withdraw the question.
Any objection to the witness, Deputy Fisher, being excused from the proceedings? Ms. Gillette
No, Your Honor.
and Mr. De Hoyos.
No, that's fine, Your Honor.
And the Deputy Fisher, you're free to stay or go if you wish.
Your Honor, in a traffic case, in a traffic stop, officers do not have to have probable cause beyond a reasonable doubt. They have to have a reasonable inference. An inference is much, much, much lower. An officer is allowed to use their training and experience in the totality of the circumstances. As Deputy Fisher testified, it doesn't matter what's behind the car. He is focused on the front window of the vehicle. Officers have experience we don't have. I've ridden with several officers and they'll be like, that vehicle's going too fast, flip their radar, be able to catch the exact speed. But you can't do that with window tint. It's based on the training and experience of the officer. Deputy Fisher has said all of the officers he has rode with use this same technique of turning on your high beams. Our troopers can't tell you an exact number, but I can tell you they write a ton of window tint tickets in my jurisdictions and others. I have two that write a lot of window tint tickets. They can't give you a specific number either when they are traveling down the road, but they sure can tell at night and during the day that the window tint is too dark based on how the lights pass through the windows and through the vehicle as to whether or not they can see the person that is inside the vehicle. This is also true during the day because there are so many vehicles you can't see into because of limousine tint or darker tints that block the view. It causes an officer safety problem. It causes a safety problem across the nation. And so that is why Kansas has this law. Miss Cowan, upon being stopped, was discovered to have an active warrant because she's the registered owner of her vehicle. That would necessitate further detention past just a window tint test. The window tint was tested and Officer Deputy Fisher was absolutely correct. The window tint was dark. The window tint ended up having a visibility that was below 35%. Her window tint tested, as Deputy Fisher testified, at 11%.
Now the state makes its last stand. After the stop, they found things. The tint did test at 11%, under the limit. Cowan had an outstanding warrant out of Butler County. And the prosecutor's argument comes down to, see, he was right. Look what we found. But that is the trap, and the law closes it. None of that was known when he decided to pull her over. You cannot reach forward in time, find something later, and use it to justify a stop that had no legal basis at the start. If the reason for the stop was not valid, then everything that came after it comes from a stop that should never have happened. In law, they call it fruit of the poisonous tree. A bad stop cannot grow good evidence.
Argument for the defense, Mr. De Hoyos.
So, Your Honor, the reason I was not prepared to play that video was because I didn't expect the officer's testimony to be different from the facts shown in the video. Specifically, there were other vehicles on the road. There were vehicles in close proximity. And we don't have any kind of science studies or anything else supporting the idea that this is an unreasonable association. I think what this is akin to is bite mark evidence, which was outruled in the 70s and 80s. At the end of the day, Judge, I mean, this is a hunch, a guess, not a truth. The difference between some of the examples Miss Gillette uses, wherein somebody leaving a place in which there was a robbery, is yeah, there was a crime there. That's the difference. By that point, there was a crime. There was a known crime, right? This is, let's go see if that's too dark and pray we're right. And the idea that we do this all the time is not a defense. No, there is no science supporting this. There is no study supporting this. There's no national training or even localized training on something like this. This is akin to something you learn on the job without having any kind of scientific support to demonstrate. Now, Judge, it may be perfectly reasonable to say that law enforcement officers are allowed to make observations with their eyes to determine concerns in courses of conduct. But Judge, this is a used tool every single time and time again, without any kind of studies to show that it's accurate, studies to show that it's amenable to these situations. We don't have any kind of evidence or science describing how that vehicle being behind it changes that reflect. And what if that vehicle is reflected? What if it's matte surface? We don't know because there's no science that supports the idea that this is reasonable to go about this way. Now, being right at the end of the day, that doesn't change whether or not the stop was initiated lawfully and legally. And so when we take this case in front of you, just this case, and we isolate it to its bare bones facts, what we have is an officer says he pulled over the vehicle because the window tint was too dark. He had to make that judgment in less than a split second as the vehicle traveled 65 miles an hour in front of him at a time and place where he cannot properly recall whether that vehicle was alone or with other vehicles, whether or not any of those other vehicles on the road would have affected his ability to see the vehicle, see inside of it, and to what difference those makes, right? So here's my point, Judge. Under the circumstances of this case, I don't think it's reasonably appropriate to believe that we can conclude there was reasonable inference based upon window tint. If the officer had waited to initiate the stop until after he read the license plate and came back with a warrant, I might not have an argument here. But if the idea is we can judge anybody's window tint at night by the flash of a second, and that's reason to pull them over, well, then none of us, it doesn't really matter. Your windows are dark at night. How can we tell the difference between window tint, just the circumstances of night, or if I'm holding something up, that's not illegal either. I mean, I guess my point here is I want more than a hunch to pull people over, and this doesn't beat that.
Thank you, Mr. De Hoyos. Court has had an opportunity to view the exhibit as presented today. The court has had an opportunity to listen to the testimony of the Deputy Fisher. Subsequently, the court finds the incident occurred well after sunset. There was no moonlight. There were no street lights, and there were other vehicles on the subject highway. The court finds a factual basis has been established. So this court determines the Deputy Fisher could not establish a reasonable inference or suspicion that the window tint exceeded the 35% darkness allowable by law. Therefore, the court does grant the defendant's motion to suppress.
Motion to suppress, granted. And once that stop was ruled unconstitutional, everything the stop produced fell with it. And here is the part that should stay with you. This was not a one-time mistake. Deputy Fisher said it himself, on the stand. He does this every night that he works. The same trick. Sit in the dark, high beams on, guess at the tint as cars fly past, and pull people over on a hunch. That same method, that same deputy, has already run into trouble in another case, in front of another judge. A pattern hiding behind the words, "We all do it." The state has filed an appeal, and for now the case is not fully over. But a judge has already looked at this method and called it what it is. Not science, not training, A guess. And a guess, no matter how confident, is not enough to take away your freedom on the side of a road. If there's a case you want me to break down next, drop it in the comments. This is what the inside of the justice system really looks like. Subscribe, because one day knowing your rights might be the only thing standing between you and someone who forgot them.